pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Our next meeting is going to be Tuesday, July 9th. We have two sets of minutes to approve. Do I have a motion to approve the minutes of April 9th?
As amended.
So moved. Second. All in favor?
Aye.
Aye. And a motion to approve the minutes of May 14th.
As amended.
Is there a second? Second. All in favor?
Aye.
Any abstentions?
Yes.
Remember that one. All right, let's just talk about the order of tonight's meeting. We do have one decision. We'll go through that decision. We're just going to read the decision. There's not going to be any public discussion about it tonight. We do then have a couple public hearings, so any items that this board has already had an opportunity to review pretty thoroughly, we're going to put them out there to look for neighbors to provide us with comments. That we will then go to a number of reviews, some that we've seen once or twice before, but just we've needed some additional information. And then there are just some brand new applications that this board has not seen. So there will not be public comment on those reviews tonight. At such time as they'll be scheduled for a public comment or a public hearing, neighbors will be notified. So with that being said, we're going to start with the item number 1, Decision Appeal 3569, Homeland Towers. Yes, sorry. We have 2 board members who are recusing themselves, and we're going to ask Mary Seminara to come on up. She is filling the vacancy created by one of the individuals that is recused. All right, I'm going to offer the motion, probably just because I'm the most familiar with the decision at this point. So this is the decision in order, Homeland Towers LLC, 23 Dartantra Drive, Hopewell Junction, New York, 12533, appeal number 3569. In this, and folks, you're going to bear with me, it is rather long decision. There are a number of citations in here and cases that we've cited. I'm not going to go through them all. I'm just going to kind of reference the fact that there will be citations. The clerk will have 5 days, in which time that she'll file this with the town clerk, so there will be a public review of this document available within, we're at the end of the at least by the end of the 5 days, if not sooner. All right, so it will be available, not at tonight's meeting, but it will be available in a couple days. So in this application, the Town of East Fishkill Zoning Board of Appeals, the ZBA, the applicant, Homeland Towers LLC, is requesting a special permit to locate a wireless telecommunication facility here in Tower, consisting of a 150-foot tall monopole and associated equipment on the property located at 23 Dartantra Drive, Hopewell Junction, New York, 12533. The subject property is in the ownership of Tufaro, pursuant to Section 194-80 of the Town of East Fishkill Zoning Code. The applicant is also requesting a 40-foot height variance for the proposed monopole, as well as a wetland watercourse disturbance permit. The application. In its ZBA application, the applicant states, quote, with this proposed facility, Verizon seeks to provide reliable wireless service along the Deconic State Parkway and Route 82, as well as the surrounding local roads, residents, and businesses located in the vicinity of the premises, end quote. The applicant's premises is an approximately 16-acre property located within the R1 residential zoning district, consisting of undeveloped forested land and a small wetland area and associated intermittent water course along its northern portion. Pursuant to the schedule of permitted uses in Section 194-78A of the East Fishkill Zoning Code, hereinafter the zoning code, the installation and operation of wireless telecommunication facility is permitted in the R1 zoning district, subject to the issuance of a special permit from the Zoning Board of Appeals. By its application, Homeland Towers proposes to construct a 150-foot tall monopole within an associated 75-foot by 75-foot fenced compound located in the central to northwestern portion of the premises. The proposed monopole and equipment compound will be enclosed by a 6-foot tall security fence and will contain a 12-foot wide double swing gate located on the western side of the compound. The proposed monopole will be engineered to accommodate Verizon's proposed facility, as well as the future co-location of up to 5 additional wireless carriers. Homeland Towers is willing to coordinate with other wireless towers in the future in order to facilitate such co-location. There's an an exhibit in the appendix that is available just relating to this. Verizon's tower will consist of mounting 12 panel antennas at a centerline height of approximately 146 feet above grade level on the proposed monopole, and installing an approximate 30-foot by 12-foot associated unmanned equipment shelter within the proposed fenced compound. Verizon's proposal will also include a global positioning satellite antenna on its cable bridge within the compound, which will be used not only to operate the wireless facility, but also to enable Verizon to comply with the FCC's regulations governing the implementation of wireless enhanced 911 Phase 2 automatic location identification. These improvements are detailed on the site plans accompanying the application prepared by Tectonic Engineering and Surveying Consultants, PC, dated October 25, 2011. Verizon is licensed by the Federal Communications Commission, FCC, to provide wireless telephone services throughout the state of New York, including Dutchess County. Verizon states that its FCC license is required to complete the construction and build out of its wireless network in its federally licensed service areas, which includes the town of East Fishkill. Verizon states that there is a public need for wireless telecommunication services, as evidenced by the granting of licenses by Verizon by the FCC. Verizon further states that its existing sites located in and near the town of East Fishkill are unable to provide reliable coverage in this portion of the town, particularly along the Taconic State Parkway and New York State Route 82, as well as the surrounding local roads and areas in the vicinity of the premises. Again, there's another exhibit. The town of East Fishkill zoning map and code places the premises in the R1 residential zoning district, section 194-76 through 194-84 of the town of East Fishkill zoning code, collectively the town's wireless law, comprehensively regulate the installation of commercial communications towers and antenna installations in the town. The proposed facility constitutes a communications facility as defined in section 194-3 of the code. Commercial communications facilities such as the proposed monopole and its associated compound are permitted in the R1 zoning district, subject to obtaining special permit approval from the ZBA. According to the town's wireless law, co-locating on existing towers or eligible tall structures is preferred to the construction of new towers, except where it is shown that such co-location is undesirable or unattainable. Based on an extensive search of the area, Homeland and Verizon state there are no available existing tall structures or towers that meet Verizon's radio frequency needs for purposes of providing reliable wireless coverage in the targeted area of the town. Again, another exhibit. Verizon is seeking to install its facility on Homeland's proposed monopole to remedy its perceived gap in reliable coverage in the targeted area. Homeland Tower submits that its proposed facility has been designed and sited with the goal of minimizing potential impacts on the surrounding area. It will be located on the central to northwestern portion of a well-vegetated, approximately 16-acre property. It is situated beyond 3,000 feet from certain scenic areas and ridgelines identified in the town's wireless law, including the intersection of Route I-84 and the Taconic State Parkway, as well as the Appalachian National Scenic Trail, Hosner Mountain, Stormville Mountain, and the mountains of Wikipe. The proposed monopole will also be set back over 500 feet from the nearest residential habitable structure and over 800 feet from the nearest local road. The applicant believes such placement on the premises should create a landscape buffer due to the topographic location and existing vegetation surrounding the proposed site. On-site vegetation will be preserved to the extent possible to help maintain this buffer, particularly along the borders of the underlying property. Thus, Homeland Towers states that the facility has been proposed, quote, in the least intrusive available location to remedy Verizon's gap in reliable coverage, while also providing an opportunity for future co-location of up to 5 additional wireless carriers, end quote. Pursuant to section 194-84D of the town's wireless law, the maximum permitted height of a freestanding tower in the R1 zoning district is 110 feet. The proposed facility has been designed at a height of 150 feet, with Verizon's antennas located at a centerline height of 146 feet. Accordingly, Verizon believes this facility will satisfy the radio frequency objectives for Verizon's target area because it will provide reliable wireless coverage to a significant portion of one of its gaps in service in the town of East Fishkill. Again, there's another exhibit. The applicant argues this height also enables Homeland Towers to comply with the goals of the town's wireless law, which requires that new communications towers be able to accommodate the co-location of future carriers. Verizon is one of only a handful of wireless carriers licensed by the FCC to provide wireless service to Dutchess County. Pursuant to FCC order and regulations, Verizon must provide safe, reliable, and readily available wireless telephone service to the public. Given the foregoing, and since at least 1993, courts in the state of New York, including the New York State Court of Appeals, have held that wireless companies are public utilities for zoning purposes. There's a citation here. The ZBA's review of this application is governed by certain legal standards set forth in Section 704 of the Telecommunications Act of 1996, sections of the New York State Town Law, and relevant case law. As the board is aware, generally the issuance of a variance is governed by the standards set forth in Town Law Section 267B. However, it has long been recognized by the prevailing case law in Newark that public utilities are not subject to the same exacting standards necessary to obtain a variance as are other entities. Instead, when reviewing a variance application by a public utility, the ZBA must apply the less restrictive standard of public necessity. The difference in these standards has been set forth as follows. The utility must show that modification is a public necessity in that it is required to render safe and adequate service, and that there are compelling reasons, economic or otherwise, which make it more feasible to modify the plan than use alternative sources of power, such as may be provided by other facilities. And where intrusion or burden on the community is minimal, the showing required by the utility should be correspondingly reduced. Bunch of citations. In short, the public necessity standard provides that a zoning board may not exclude a utility from a community where the utility has shown a need for its facilities. More citations. The public necessity standard applies to all public utilities and the development of their new facilities as well as the expansion of existing facilities. Thus, a ZBA must utilize the following less restrictive standard in evaluating a variation application. A balance must be maintained between those interests of the locality which can be expressed by zoning ordinances and the need of the community which must be served by the utility. Not only is it within the power of the respondent, in this case the city, to grant a variance, but the fact that the applicant is a utility calls for the balancing of interests. Court citation. After careful evaluation of the surrounding area, it was determined by the applicant that siting the proposed facility at the subject premises is the most appropriate location to provide reliable wireless service to the area of the town. There's another appendix listed. The applicant states that this proposed facility will not generate additional traffic because it is unmanned, and Verizon only requires monthly maintenance visits by a service technician that generally last for an hour. During these infrequent visits, the technician will use the proposed driveway to access the parking area and equipment compound. In addition to those maintenance visits, the facility will be monitored by Verizon 24 hours a day, 7 days a week from a remote location. Therefore, the facility will have no impact on pedestrian or vehicular traffic. The proposed wireless communications facility also requires a wetlands and watercourse disturbance permit in accordance with Chapter 110 of the Town Code, the Wetlands Law. The town regulates activities that involve the disturbance of watercourses and or wetlands that are equal to or greater than 1/2 acre as well as their associated buffer areas. On September 19, 2011, Tectonic Engineering conducted a formal wetlands investigation at the premises in accordance with Sections 401 and 404 of the Clean Water Act, Articles 15 and 24 of the New York State Environmental Conservation Law, as well as the Wetlands Law. As a result of this investigation, Tectonic believes that certain federal and town-regulated freshwater wetlands and an associated intermittent watercourse are located within and around the proposed area. While the delineated portion of on-site freshwater wetlands measures approximately 0.38 acres, a portion of this wetland area also extends off the eastern boundary of the premises. Therefore, it is presumed that the total wetland in question meets or exceeds the 1/2 acre threshold set forth in the Wetlands Law, but it is below 1 acre in total area. As currently planned, direct disturbances on the subject wetland are limited to only 942 square feet or 0.022 acres. There's an appendix or plans to reference here. Despite the fact that the Wetlands Law does not clearly set forth or establish jurisdiction over upland buffers for wetlands greater than 1/2 acre, but less than 1 acre, Homeland Towers has voluntarily applied a 50-foot buffer to the subject wetland areas. As currently planned, only about 0.23 acres of disturbance would occur within this voluntary buffer area. Submissions to the board. This application has been the subject of several reviews and then several public hearings held on November 13th, 2012, December 11th, 2012, February 12th, 2013, March 12th, 2013, and April 9th, 2013, when the public hearing was closed and the time for decision and order was extended by mutual agreement to June 12th, 2013. In connection with this application, voluminous submissions were received from the applicant's attorneys and other professionals, from the neighbors' attorneys and other professionals, from the town's attorneys and other professionals. Specifically, the town engaged the services of a radio frequency RF consulting engineer, Ronald E. Grafe, PE, who guided the ZBA through esoteric radio frequency and cell tower issues and reviewed the technical issues in the submissions from the applicants and the neighbors' RF professionals. Mr. Grafe was knowledgeable and very helpful in his assistance to the ZBA on the RF and cell tower issues. The ZBA's decision. This board has carefully reviewed and considered the voluminous submissions received from the applicants, the neighbors, and the town, and the lengthy testimony received from all parties at the public hearings recited above. After due deliberation, this board hereby denies the applicant's application for the following reasons, among others. 1, no significant gap in coverage. The applicant states in its application that the town that, quote, Verizon's existing sites located in and near the town of East Fishkill are unable to provide reliable coverage in this portion of the town, particularly along the Taconic State Parkway and New York State Route 82, as well as the surrounding local roads and areas in the vicinity of the premises, end quote. This is the applicant and Verizon's claim, a, quote, gap in coverage in this area of East Fishkill. The applicant does not have an absolute or unfettered right to construct the proposed tower simply because the construction constitutes a permitted use. The fact that a gap in service may exist in an area does not mean that the public interest necessarily tips the balance in favor of allowing a variance, particularly a substantial 40-foot variance as requested herein. If that were the case, local boards would be obliged to approve virtually every application brought before them, and a public hearing would be a mere exercise in futility. The Town Zoning Board of Appeals has considerable authority and discretion to deny the application. The Telecommunications Act of 1996, the TCA, neither mandates nor guarantees the right to seamless coverage, ubiquitous coverage, or 100% coverage. Congress anticipated that certain gaps in coverage would exist and that there would be unserved areas. There's a citation here for reference. The issue of seamlessness is not a legal mandate. It is a corporate desire of the applicant that the ZBA is not required to fulfill legally. The Telecommunications Act of 1996 expressly prohibits local zoning authority over personal wireless services subject to the following limitations. 1, there may not be unreasonable discrimination among providers of functionally equivalent services. 2, personal wireless services may not be prohibited. And 3, a request may not be denied on the basis of the environmental effects of radio frequency emissions. The TCA further requires that any decision regarding an application must be in writing and supported by substantial evidence. Several citations. Substantial evidence requires more than a scintilla but less than a preponderance. Again, several citations. Substantial evidence has been defined by the United States Supreme Court as, quote, such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Again, a number of case citations. Importantly, if the court finds that even one reason given for the denial is supported by substantial evidence, the decision of the local zoning body cannot be disturbed. Mr. Grafe educated the ZBA in his initial report dated April 10, 2012. In reviewing a composite of 2 coverage maps, Mr. Grafe wrote, quote, moreover, the proposed site only provides approximately 20% new coverage, unduplicated, and nearly 80% overlaps with existing coverage provided by the Hopewell Junction Freedom Plains HD4 site and perhaps the LaGrange G1 sites. Such excessive overlaps is an inefficient use of the radio spectrum. It is relevant to note that while some coverage overlap is required to accomplish seamless handoffs between cell sites, this overlap is generally designed to be approximately 10%, end quote. Mr. Grafe also noted that, quote, the proposed Hillside Lake site is approximately 0.9 miles to the southwest of the existing Sylvan Lake site, end quote. A site with which Verizon purports it cannot modify to increase its coverage. He further stated that, quote, this location is not in the ideal location with respect to the regular reuse grid, and, quote, quite frankly, it is too close to the existing Sylvan Lake site, end quote. This close proximity of an existing site results in a condition known as, quote, pilot pollution, end quote, recognized in many technical papers, many authorized by Verizon, that results in system interference, typo, poor handoff, and a loss of system capacity. What we have in this application is not a significant gap because there is tremendous redundancy and overlap from the proposed tower with existing coverage. Moreover, although numerous calculated and drive test propagation plots of existing coverage were presented in support of its case, Verizon provided no actual call or traffic data from its system demonstrating that its customers were suffering from a lack of service or dropped calls in the two distinct but very small purported gaps, estimated by the applicant's data to be approximately 1/4 mile and 1/2 mile, which a driver on the Taconic Parkway would pass through in approximately 20 to 35 seconds in coverage along the Taconic Parkway. In its entire justification for the site was based on its corporate standard of a signal strength that it had determined. 2, Section 6409 of the Middle Class Tax Relief and Job Creation Act of 2012, the Act. The ZBA has been advised that a significant danger exists for a single carrier tower. Verizon Wireless, Verizon, has stated repeatedly that the minimum centerline height needed for coverage to the target area is 146 feet. Carriers other than Verizon will have limited to spotty coverage below that height. This is supported by Verizon's own maps, which showed declining to zero coverage to the target area at heights below the 146 center line. Verizon's initial RF analysis confirms this and states in pertinent part, quote, the proposed installation located at Artantra Drive will have an antenna center line of 146 feet. A lower antenna center line would limit the coverage due to the terrain blockage and the surrounding foliage. The area around the intersection of Route 82 and the Taconic Parkway would also be greatly impacted by a lower center line. Not only would the foliage be a factor, but the terrain would significantly weaken the RF signal, emphasis added. It was demonstrated, however, by the propagation maps presented that the lack of coverage in the Route 82 interchange area could be well served by the addition of a new site to the north in another municipality. The applicant states that Homeland Towers, quote, Homeland Towers would agree to the board approving a tower structure that is capable of future expansion to allow for additional co-location opportunities above Verizon's proposed location, end quote. It appears that co-location as presented by the applicant throughout the review and public hearing process is not feasible due to topographic considerations. Now the applicant offers to permit the ZBA to approve a tower that could rise above 150 feet, sought in order to facilitate realistic co-location. Documents submitted by Verizon show that in the tower's current incarnation, only Verizon would achieve full coverage to the target area. Other carriers will likely encounter significant signal attenuation, and minimal or no coverage is achieved at heights below the 146 center line. Verizon admits that, quote, at a lower center line than 146 feet, the Verizon wireless signal would be impacted by additional clutter, end quote. Certainly this could apply to carriers other than Verizon as well. By building a tower that could apply to carriers by building in tower height expansion, the applicant could increase the height of the tower without going through the rigorous requirements of the zoning code as it pertains to construction of a new tower. And the ZBA could be bound as a matter of federal law to approve any such increase under the recently enacted Middle Class Tax Relief and Job Creation Act of 2012, which modifies the TCA with respect to co-location. Section 6409A of the Act states in pertinent part that, quote, a state or local government may not deny and shall approve any eligible facilities request for a modification of an existing wireless tower or base station that does not substantially change the physical dimensions of such tower or base station, end quote. In other words, under federal law, once the proposed tower is constructed, the applicant determines that co-location as anticipated currently is not feasible. The applicant can apply to locate any number of additional antenna on the tower and to increase the height of the tower up to the point permitted legally. In that case, based upon federal preemption, the ZBA would have no choice but to approve such an application regardless of any negative impact on the community or the ZBA's review authority as set forth in East Fishkill Zoning Code, Section 194-79. Based upon the applicant's submissions, coverage below the 146-foot center line of the proposed 150-foot tower is essentially useless, and a single carrier tower serving Verizon only is likely. The reality of the situation is that in order to co-locate additional carriers on the tower, expansion may be required, and 150 feet may not be the final height of this tower when all is said and done. Not only does the applicant seek currently a substantial height variance of 40 feet, it now implies that additional variances could be sought which may increase the height of the tower. Such expansion would have a substantial effect on the neighboring property owners. The applicant also did not provide any information or minimal impact alternate technologies, i.e. wideband repeaters or some type of distributed antenna system that could provide the relief as well as other carriers might seek in filling this obvious, very small gap in coverage along the Taconic State Parkway. 3, aesthetic harm. The Second Circuit Court of Appeals and the New York Court of Appeals have held that aesthetics is a permissible ground for local zoning decision and denial of a permit. Several citations. Quote, under the TCA, we find that aesthetics qualify as a permissible ground for a denial of a permit only if we can conclude that there is, quote, more than a mere scintilla, end quote, of evidence before the board on the negative visual impact of the cell sites. Again, several citations. Further, the state legislature has found and declared that, quote, the maintenance of a quality environment that at all times is healthful and pleasing to the senses is a matter of statewide concern, end quote. New York Environmental Conservation Law, well, there's some citations here. A telecommunications provider is not granted carte blanche authority to dictate the number and locations of its facilities. Again, a number of citations. When weighing the extent of intrusion of a proposed facility, the municipality may consider the aesthetic impact of a facility. Again, several citations. Okay, based upon a review of the various site plans, actual photographs, and visual projections, the proposed tower and associated equipment compound will be highly intrusive to the communities affected. Specifically, A, the tower will be 150 feet high with a fenced equipment compound comprising thousands of square feet that can be seen from numerous vantage points. B, the tower will stand approximately 3 times the height of the tallest existing tree. C, the tower will not be disguised as a tree or a flagpole and will be an eyesore in mature residential neighborhoods, thereby impacting their character and the picturesque quality of the surrounding area. D, numerous trees will be cut down, thus making the tower and compound even more visible from a number of locations in the affected neighborhoods, including those directly across the Taconic State Parkway, here in the TSP. And E, the Taconic State Parkway is a nationally designated scenic byway from Chappaqua Road in Westchester County at the southern end to the northern end of the parkway, and the presence of the proposed tower will impact the viewshed of the Taconic State Parkway. The tower and the equipment compound fail to comply with the provisions of zoning code section 194-80A11B, and they do not minimize accord with the New York Environmental Conservation Law, as it is not pleasing to the senses in any way, shape, or form. 4, property values analysis. In Sprint Spectrum versus Willith, with the citation, the Second Circuit stated that, quote, an agency is not precluded from considering economic injury and determining whether a negative aesthetic impact is significant, with the citation. Reduced property values is a form of economic injury. Further, in Omnipoint Super, the court noted that the planning board credited property expert testimony that the tower's adverse visual impact combined with public perception that cell towers may pose health hazards would result in a decline in the marketability of homes in the neighborhood. In the affidavit of Anthony V. Serino, sworn to on December 4th, 2012, which was made part of the record of the public hearing held on December 11th, 2012, Mr. Serino provides his professional opinion and analysis regarding the devaluation of homes in the affected neighborhoods caused by the proposed tower. Mr. Serino is a well-respected local real estate broker who is also a director of the Dutchess County Board of Realtors, as well as a sitting member and former chairman of the LaGrange Assessment Grievance Board. Mr. Serino's professional opinion on the loss of property values resulting from the tower is instructive. He states that property values decline approximately 20% in areas where a cell tower exists. He states in pertinent part as follows. There is a stigma related to such towers, cell towers, and aside from their obvious and undeniable unattractive nature, this will be considered a major eyesore and hindrance to anyone attempting to sell their home in these communities. In my experience, many people are reluctant to purchase homes in neighborhoods where cell towers are located because there is a perception among potential buyers that a health risk exists, whether real or imagined, and regardless of government assurances. It is this perception combined with the adverse aesthetic impact that helps drive down property values, both as a function of price and by a reduction in the number of potential purchasers. To date, I have never, nor have I ever heard of, a buyer requesting a view of a cell tower. In response to the Serino affidavit, the applicant offers an unsworn letter from Edward J. Ferrarone, dated March 10, 2013, the Ferrarone opinion. The Ferrarone opinion claims that construction of the proposed tower will not impact property values negatively, and incredibly that higher prices are paid for homes with a view of a cell tower. As detailed below, significant deficiencies exist in the Ferrarone opinion, such as A, failing to provide any data concerning the effect of a cell tower on property values in rural Dutchess County. Instead, it furnishes data mainly from Westchester County and Rockland County, which contain many heavily built-up commercial areas where the impacts of cell towers are significantly less intrusive and noticeable. B, the bulk of the data provided is relatively antiquated. C, no photographic evidence is provided for any location identified to show any impact, adverse or otherwise, of the tower on the surrounding area. D, the examples provided have absolutely no relevance to the existence of a 150-foot cell tower located in a mature residential neighborhood. 5, the Town of East Fishkill zoning code. The town zoning code, as applicable to cell towers, deals directly with issues of intrusion and burdens on the community. Section 194-78 of the zoning code mandates expressly that construction of a commercial cell tower must comply with the general standards for obtaining a special permit set forth in Article 9 of the zoning code. Article 9 includes Section 194-44, titled Standards for All Special Permit Uses, which does not permit the granting of a special permit unless each and every condition contained in that section is met. In addition, Section 194-82 of the zoning code, titled Standards for Issuing a Special Permit, and Section 194-76 of the zoning code, titled Commercial Communications Tower and Antenna Installations, both incorporate the provisions of Article 9. Nothing contained in Section 194-76 through and including Section 194-84, including the following?
Yeah.
Okay, thank you. There's an abbreviation here that's not in English. Of the zoning code expressly exempts any application from compliance with each and every standard set forth in Section 194-44. Thank you, and sequence thereof, which is part of Article 9. The conditions of zoning code Article 9, all of which must be met for issuance of a special permit, include but are not limited to: A, the impact on the district concerning location and the size of the use, as well as the nature and intensity of the operations involved. B, the impact on adjacent properties with relation to location, nature, and height of the buildings, walls, fences, and landscaping, so as not to hinder or discourage appropriate development and the use of adjacent land and buildings. C, impacts on neighboring properties with relation to severe impacts caused by reason of noise, fumes, odors, vibrations, flashing lights, or other operational characteristics. And D, the impact on surrounding properties with relation to the reasonable safeguarding of neighborhood character and surrounding property values. Further, Section 194-82 of the zoning code states in pertinent part that no special permit for a communications tower shall be granted absent a finding by the zoning board that the applicant has met the standards for special permits set forth in Article 9 of the zoning chapter and other requirements. The application in this instance fails to meet those conditions in the aggregate, particularly with respect to the impact on surrounding properties as it pertains to safeguarding neighborhood character and the devaluation of real property. It is also noted that the ZBA has approved special permits associated with 8 other cell towers in the town that have met the conditions of the zoning code. Most recently, in October 2012, the ZBA approved an application for a 110-foot tower. Conclusion. Among the various submissions to this board, hundreds of letters of protest have been submitted to the ZBA, as well as a petition containing numerous signatures. Various experts have testified and made written and visual submissions on behalf of the applicant and the residents, and the ZBA has considered Mr. Graves' professional conclusions as to the impact of the project from aesthetic and technical viewpoints. Indeed, Mr. Graves has opined that a gap exists, but he did not describe or otherwise characterize it as significant. Mr. Graves stated that it is the role of the board to determine whether the gaps are or are not significant. We hereby determine that the gaps revealed in this application are not significant. The ZBA has broad legal authority and discretion in this instance to deny the application and act in the best interest of the town. Town zoning ordinances exist to protect residents and property values, and variances should not be granted cavalierly. The ZBA is not obligated to approve the desired site so that Verizon can meet its coverage objectives with a single facility or any facility for that matter. Although a balancing must occur between the interests and concerns of the communities on the one hand and those of wireless service and infrastructure providers on the other, the severe and adverse impacts on the community here in the aggregate far outweigh the desire or need of the applicant. Throughout the review process, there was absolutely no discussion by the applicant as to how this project would benefit the residents impacted or how the neighborhoods would be affected adversely. Although the applicant denies any adverse impact, the reality based upon substantial evidence contained in the record is markedly different. The beauty and character of bucolic East Fishkill neighborhoods and the rural East Fishkill landscapes will be affected negatively. Property values will decline. The height of the tower may increase significantly over the course of time. The applicant has not shown concern for those who will be harmed by the proposed project. The neighborhood character with its attendant adverse financial consequences is a result the ZBA should guard against here and does so by this decision and order. For the foregoing reasons, as well as those contained in all the submissions and testimony presented and received by the ZBA, this board hereby denies the applicant's application in its entirety. Do I have a second? Thank you. Votes as follows. Jim?
Aye.
Tara? Oh, I'm sorry. Not even looking up.
Yeah.
Barbara? Aye. And Mary?
Aye.
And myself, aye. All right. Can't see now. All right, there's a couple typos on here. We need
Yeah, I
to-
found some.
Oh, just a
Good.
few.
Yep. Here, I'll show you some. Just look at that. Wow. Ooh, there's a few people there. Norma, you need a breath?
Really?
Wow.
I was say, I need some water.
I was thinking that we should have decided that you maybe read 4 pages,
Yeah,
I
you
read
say.
4 pages.
Yeah, give me 1 second here.
That's not a bad idea, Jim. It's not a bad idea.
Is what?
No, but
Should have thought of it
We had to get
beforehand. Yeah,
All right, let's keep moving
I
on
got to the point
here.
where I was ready to finish words.
Item number 2 is a.
do we have to get our new members back?
Oh, sorry. Thank you. I'm ready to move right along. There's Pam.
We heard the uproar and clapping and everything.
Oh, so you,
We were like,
because it was time to come back.
yeah, they were cheering us to come back.
All right, so item number 2, we're on our first public hearing. This is Appeal 3627 Conradi. David Conradi, 55 Clove Branch Road, Hopewell Junction, is requesting a 25-foot rear line variance for a proposed 26-foot by 26-foot shed, a 10-foot rear line variance for the existing house, an 18-foot rear line variance for the existing gazebo, a 16-foot front line variance for an existing awning, and a 7-foot front line variance for an existing 10-foot by 10-foot shed pursuant to Section 194-107 of the zoning ordinance. All right.
Motion to open the public hearing?
Thank you.
Second.
All in favor?
Aye.
Aye. All right, we have reviewed, I'm going to ask you to just sit down.
Okay.
We're still on. We have reviewed this application a number of times. We have asked you to provide us some additional information. It appears you are providing us some pictures tonight. Yes. Okay, so there's 3 packets that we have to share. So again, this is a property that is not very visible. It's not visible at all, honestly. You barely
Right, so I
see the
think that-
signs for your roof right now and for the zoning board. We saw that. But otherwise, you don't, from Clove Branch Road, the property is not visible.
Right.
Okay, so now we're looking at what you've got here. So you're using the awning for the purpose of storing wood?
Largely some trash cans.
Okay. We've got a gazebo that's clearly surrounded by foliage.
Right. And I've tried to take some pictures in the directions of the principal neighbors who might be affected by the shed.
Okay.
And the pictures should indicate you can't see the neighbors' houses from that location. I think they will have a great deal of difficulty seeing the shed from their
Okay.
houses as well.
The shed that appears to have, is it a blue roof or is it a,
It's,
is that the existing shed?
That existing shed is, it's aluminum, actually, yes.
Okay.
The existing, but the shed example, that's just an example.
Oh, the shed example, that one, that's basically the plan that I'm going to follow. I wanted you to understand that it's the body of the shed, the enclosed portion is going to be
Oh, that's
roughly
an example.
16 by 26 with a lean-to on the side,
Okay.
which will not be very high. This is, I think I have the purpose in there as well. You'll see a very small tractor picture, which is on
Right.
our porch, and my wife would love to get the porch back.
Okay, so this is the shed that you're proposing to put there?
Correct.
So it has side access door?
Well, the doors may or may not be exactly like that, but,
Okay.
right.
The door in the front just doesn't seem very large, so you wouldn't be able to get your tractor in and out of there?
Well, it's a very small tractor, so but the door will be large enough for that. It's just a model.
Okay.
The company that does the sawmill provided that picture.
Okay, you have a looking south view of McDonald from proposed site.
Yes.
So you
And the
don't have full foliage, you don't have full screening from your
Right.
neighbors?
But even without the foliage, it's really pretty difficult to see through the
Well,
brown.
the roof that we're seeing of some structure, is that on your property or theirs?
The roof you're seeing is the gazebo, right? So the fence in the foreground is my own fence. The gazebo is the gazebo you've seen in another picture.
Okay,
And then after this picture that you see, the next one is taken from the gazebo location towards the neighbor's house to show you that even that much closer to the neighbor's house, it's very difficult to see their house through the foliage. And then the picture after that is actually from the corner of my property closest to their house. You still have difficulty seeing through the forest. It's rather dense.
okay.
Okay, excuse me,
Yeah.
the picture that you took of the gazebo from the fence, you went onto their property?
No, I went to the corner of my property. Oh, no. Which picture can you, it's got a letter.
It says G,
G.
looking south, view of McDonald from, so that's what, it sounds like we'd be looking at them.
So-
But it sounds like you're really at
G,
McDonald's to
G
your
is,
back.
G is from the proposed shed site, looking across my own property at the gazebo you see on the left. And in the center of the picture, deep in the forest, there is their house.
Oh,
Okay, and if you look at,
Oh, I see, okay.
H is the same picture, but from a closer perspective, from the gazebo. I is even closer, from the very edge of my property, that's what you see. And then J is actually from the very edge of my property back towards the building site. So if you look at J, you're looking across my yard, you see my house, and the shed will be on the other side of the house.
right.
I see.
So from the closest neighbor, I think, essentially, they'll see my house and then a speck of the shed on the other side of my house.
Okay. All right. Questions or comments from board members?
No, I'm good.
Is there anyone here to speak for or against the appeal by David Conradi, 55 Clove Branch Road, Hopewell Junction, requesting a variety of variances?
Yes, Chair Drummond, members of the board, my name is Tom McDonald. I am the adjoining landowner, along with my wife, Catherine McDonald. And as you may know, I delivered a letter to you on June
Right.
3rd requesting a continuance of the matter for 2 months so that my wife, the co-owner of the property, can be here. For some reason, we did not receive notice of this hearing. We did find out from a neighbor about it. But more importantly, perhaps, my wife is a nurse. She is working at Phelps Memorial Hospital this evening. Her schedule is set 6 weeks before. She, as well as I, am adamantly opposed to granting the 3 variances that most directly affect our property in this case. And we would like an opportunity to both be present to express our objection to this. In addition, we would like to be able to fully consult with counsel, real estate attorney, so that we can more fully prepare our case. I note that 4 of the 5 variances that Mr. Conradi is requesting are on structures that are already in existence. Apparently, variances were not requested when these structures were built. So I doubt that there's any urgency in the matter if this were put off for 2 months. My wife's schedule, as indicated in the letter, is set 6 weeks in advance. So I have to ask for a 2-month continuance so that we can really fully develop this matter. Again, I would like to point out to the board that this is one of the matters is a 26 by 26 foot shed. That's almost 7 times the square footage that the town zone permits. He's also asking for a 25-foot rear line variance, and consequently, we feel very strongly that this is going to affect the character of the neighborhood. It's going to have to my knowledge, there's no such shed of this size in either the Eagles Ridge or the Dana Estates neighborhoods, which kind of like are between these two properties. And we feel this would deleteriously affect the neighborhood, and consequently, we really want additional time in order to be able to, again, fully represent our opposition to these 5 variances, or at least the 3 variances that most directly affect us. Thank you.
Which are the 3 that most directly affect you?
Yes. If you look at it, Mr. Conradi is requesting a 25 rear line variance for the shed,
Right.
a 10-line rear line variance for the existing house, an 18-foot rear line variance for an existing gazebo.
So those are the 3 that,
That most affected,
impact
I
you.
mean, frankly, our main concern is about the shed, but, the gazebo, I feel like, this obviously should have been handled differently. In other words, before these matters were constructed, a variance should have been sought. So it really makes it much more difficult for us to oppose when there is an actually existing structure.
we're here to listen to you, so if
Okay,
you're- if you
so
have
that is our position on the matter.
Okay, yes.
You're aware that the structure's
Yeah.
predated zoning? Maybe not the gazebo,
Yeah, no, I
but
don't know
The
that.
house would probably.
the house predated zoning.
Yeah, the house predated zoning, clearly.
The
Okay,
pool
okay,
predated zoning.
Okay, we will, with regard to the house, okay?
You're not-
We're not so vociferous about the house. But the point is, we feel that this is something that will affect our property values and the
Okay, so
character of the
let's
neighborhood.
listen to our deputy zoning administrator, okay? Because she
Sure.
can give you some background that may be helpful in
Sure.
helping you further prepare your case if you need be.
Thank you.
I don't have information about the gazebo, but the dwelling, along with an 8 by 40 deck, predated zoning. The shed is less than 100 square feet, so it only required the 25-foot setback, and the pool predated.
Okay.
That's the other, that's the
And there
pre-existing
is no
shed.
requirement, there is no size requirement. I don't know where you're coming up with 7 times.
Right.
Well, the town zoning law, I believe it's 94-107 says that shed shall not exceed 10 feet shall not exceed 100 square
Does not
foot.
require,
no,
No,
does
it
not
don't require a
building
permit
permit
for
if
less
it's less
than
than
that.
100 square
Yeah.
feet, but it does not say that you can't have a shed larger than that.
Right.
I figured the confusion was.
Okay. Okay, is there anything else you'd like to offer?
Well, I mean,
do need you to have to sign in before you leave.
if you're disinclined to grant our request for a continuance, then I have more to present. But, in other words, I have a petition from surrounding neighbors opposing the variance and construction.
Is there
But-
some
but
reason
it-
you
but-
wouldn't
but
offer
if-
that tonight anyway?
What?
Is there some reason you wouldn't offer that to us tonight?
I could offer that to you tonight as well. It's just that, we would, I feel that I really haven't had the opportunity to fully, like, for example, I was unaware of exactly how that regulation worked. I feel I'm not in a position to completely prepare adequately. And also the fact that my wife, who's a co-owner, who, again, feels very strongly about this, could not have the opportunity to attend.
I recognize that.
Is something that we feel that she should have that opportunity.
Okay, Pam,
Is there
just,
some reason why she couldn't attend the next month's meeting, though?
The problem is her schedules are set 6 weeks in advance, so that is the difficulty.
but Pam, can you confirm for us, when did this notice go out? I mean, at our May meeting, which was May 14, we assigned this for public hearing, so it would have gone out.
The letter is dated May 17th.
Yeah, I
Chair.
was gonna say, it would have gone out within days of that. Right. Do you have, these go out, return receipt, or no?
No,
Okay.
you don't.
Was there a sign posted?
Yeah, there's a sign posted. yes. But.
He doesn't drive past
He's,
that
right,
property.
he has different
Yeah,
street
different.
frontage, so I definitely recognize that you wouldn't necessarily drive by that sign. Okay, so as of May 17th is when the
That's when
letters
they
went
were
out,
mailed.
give or take a couple days, because that was.
No, they were mailed on the 17th.
No, I'm just saying, give a couple days, because that was a weekend. You might not have gotten it till the following Monday, the 20th, for most neighbors. So, all right, and at sometime in May, though, you did call the planning board office and
Right, we did
question
learn about it from a neighbor. I'm not saying, we definitely did. It's just that by that time, my wife's schedule had already been set, and she just could not attend.
Okay, let's, unless you have anything else to offer tonight, I think I'd like to hear if there's any other comments, so that we'll know whether there's an issue we need to continue or not.
Well, I'll present the petition if you would.
Okay, that's
Okay? All right, so that, do I hand that to you?
Thank you.
There are 16 signatures of adjoining property owners, including ourselves, on the petition. Well, I also have a legal argument, if you will, but I mean, you know,
Okay, let me just, again, I wanna
because
read
I don't want to, I mean, the thing is, if this continuance is denied, then I would,
we're not taking any action at this point, okay? I'd like to
all
read your
right,
petition.
well, then let me lay out a legal argument then, okay?
Can I read your petition into the record?
Absolutely.
Okay. Petition to the Town of East Fishkill Zoning Board, Appeal Number 3627. The following nearby property owners oppose the granting of a 25-foot rear line variance to permit the owner of 55 Quill Branch Road to put a 26-foot by 20-foot 6-foot shed on his property, which is nearly 7 times the square footage the town zoning regulations permit. No such building, shed, shall be larger than 100 square feet in floor area, quote, and
I don't know,
quote,
that-
shall not be erected within 25 feet of a rear, side or rear line property line, end quote. East Fishkill Town Code, Section 194-107, B1 and 2. If the board allows this variance, this precedent might permit future homes in Dane Estates and the adjoining neighborhood to put up such oversized shed, as well as placing them overly close to adjoining property lines, thereby negatively impacting the residential character of the neighborhoods. We ask the zoning board to deny the variance to ensure compliance with town zoning regulations. So it's signed by Mr. McConnell, Mrs. McConnell,
Read the addresses also, sorry.
6 Mockingbird Court for both of them. Then we have 2 residents of 4 Mockingbird Court, Manelas. We have 8 Mockingbird Court, Lewis. We have 10 Mockingbird Court, Hand. We have 16 Mockingbird Court, I can't read the name, Linda, perhaps, can't read it. 20 Mockingbird Court, Kim Schulte. And again, also 20 Mockingbird Court, Dan Schulte. We have 2 residents from 22 Mockingbird Court, DeFonso. We have 18 Blue Jay Boulevard, Mayolo. We have 2 residents of 7 Blue Jay Boulevard, the Croces. We have 1 Blue Jay Boulevard, Rusciano, and 1 Mockingbird Court, Tom Duffy. All right, so just to give you some sense of the proximity of these neighbors. So, you want to see that? Okay. All right, so go ahead. You can
Okay.
continue.
Again, I'm not a real estate lawyer, but I understand that Section 81B4B of the New York State General City Law requires the board to consider the following criteria. The first is whether an undesirable change will be produced in the character of the neighborhood or detriment to nearby properties will be created by the granting of the area variance. The shed coupled with a 25-foot rear line variance is 26 by 26 feet. That's 676 square feet. It is more indicative of a commercial rather than a residential area, okay? Furthermore, I'm aware of no one else in either neighborhood, either Eagles Ridge or Dane Estates, that has a shed of that size, okay? It will create a precedent that may permit other homeowners to put sheds of comparable sizes encroaching on adjoining properties' owners' setbacks. This would have the effect of damaging the high-quality residential character of these neighborhoods. These both are beautiful neighborhoods, if you're familiar with the area. Both of them are high-end, beautiful neighborhoods. Thus, in the language of the statute, it will produce an undesirable change in the character of the neighborhood. The second criterion is whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. The owner can put a smaller shed or two smaller sheds to accomplish this result. That will not require a rear line variance, a 25-foot variance, which is quite substantial, okay, against my property. Other owners in the neighborhood have small sheds. That is not uncommon, okay, in these high-quality neighborhoods, okay, but not a shed of this size, okay. Whether the requested area variance is substantial, a 25-foot rear line variance, in my view, is quite substantial. Now, again, he's asking for variances with respect to the gazebo, which I would again, question and object to as being likewise substantial. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood district. This is the fourth criterion. This, I see, seems to repeat the first criterion, but for the reasons already stated, the shed will have an adverse impact on physical and environmental conditions in the neighborhood. Lastly, the fifth criterion, as I'm sure you're quite aware, is whether the alleged difficulty was self-created, okay, which consider, okay, and this is exactly what this is. This is a self-created criterion. This was not something caused by natural conditions. The owner presumably is on notice, knew or should have known about the town's zoning regulations and setbacks, and should consequently, for all these reasons, the variance should not be granted. And again, you have the petition of the adjoining homeowners.
Are these improvements, are these structures visible from your property?
Yes, I mean, in other words, Mr. Conradi said that it's true. Right now, we have 1.7 acres, okay? The back part of our property is wooded. We are considering, clearing that and making our backyard better. It's kind of on a hill. But, when you're dealing with spring foliage, yes, it's hard to see these things. But in the wintertime, it's quite visible, okay? There's no question. This is all quite visible in the wintertime. And again, we're considering, we have only 1.7 acres. It's not like we have, a 100-acre estate. And so, into my mind, this affects us.
You understand that the proposed shed...
Excuse me?
You understand that his house is going to be between the proposed shed and your...
And our current house, but it's 25 feet, he wants it 25 feet from our property. And it is, if you take a look at it, I mean, I'm sorry. I mean, it's not, if you look at it, it is not completely behind his house, if you take a look at the map, okay? In other words, it is his house partially, only partially blocks it. And remember, by the way, again, his house, I'll leave that at it. So it is going to be visible, it is quite large, and it is out of character with the rest of these two neighborhoods.
So I guess I'm trying to, are you the property immediately behind him, or you're the property?
Behind him.
You're where?
We're behind him, really.
This
I
is
mean,
his.
the map is kind of funny.
This is his driveway coming up from Clove Branch
Top of
Road.
the page.
All right, and so you're saying you're back here? You're in the
Yeah,
top?
but it's really,
Or you're off to the side here? 'Cause
It's
there's a property
really-
line right here.
No, to the
you
back.
really have to look at the map like this, really. Because that's really the way it's
This
oriented.
is the subject property, this is McDonald's house, and the property goes back.
Oh, okay, so you are, it is behind.
Right.
Okay.
That's really the better way to visualize it. I know the map is a little confusing. It is.
So this is a different property here. It really is this property back here. But it is, you have a highly forested lot.
It is
Your
far-
improvements are very close to Mockingbird Court.
Yeah, I'm sorry?
The improvements on your lot, your house, and you,
Our house, yeah, our house is close to Mockingbird
and
Court.
it looks like you have a shed.
We don't have a shed. That's his property.
No. Let's have you come up here for a second, so we
Sure.
can understand which is your property. Is that a pool then? Do you have a pool?
I do, but that's his pool.
No, this is your lot right here. This is what we're getting. His
Okay, right,
his
yeah,
lot's
this is my
back
lot.
here.
Right, yeah, I have a pool.
Okay, so that's what we're just trying to understand.
Right,
So,
this is my lot.
so even the farthest property, end of his property is all forested for you.
Yeah, but the way because of the way this angle is here, you see how this is?
But where is he
Okay,
putting the
so-
shed?
So he's putting the shed here. Okay. So it's the
If you look
angle,
directly from his house, the
the
house
angle of the in other words, it's an odd lot. My lot veers to the left.
No, I understand.
So in other words, we're kind of in a direct line with his property.
Well, actually, your neighbor's lot
Right.
gets in your
Cuts
way
in,
there as
but-
well,
But
so.
nonetheless, okay, this,
And there's nothing that prohibits your neighbor from clearing their lot?
Right.
Okay, all right, just so we understand. Okay,
anything else?
now unless there's anything you wish to offer, if you have not signed in, we do need you to sign in, please. All right, is there anybody else who'd like to speak related to this?
Yeah, I'd like to put it in the record that the petition that was just put in the record, there are only 3 neighbors for the applicant that were notified and that were, only 1 individual showed up, and this is the petitioner or the person who is filing the, requesting a adjournment, Thomas Michael McDonald at 6 Mockingbird Court. There were a couple of people who have signed it from 4 Mockingbird Court and 8 Mockingbird Court, but other names that were mentioned in the petition, they are not adjoining neighbors. They may be, we do not know really how far they are from the applicant's property, so I do not know if any weight can be given to those individuals. And also Mr. Daniel Lewis and Donald McNella at 8 Mockingbird Court and 4 Mockingbird Court were notified, and they failed to show at this hearing.
Okay, plus, on top of that, there is some misrepresentation in the petition that makes me wonder if the folks even knew what they were signing.
Correct.
Well, I mean, the major issue obviously is the misunderstanding regarding the square footage.
Right.
I mean, it's not a small shed, 26 by 26.
Right.
You know. But, yeah,
That's the footprint, including the
Yeah.
covered awning. It's not-
Correct.
I guess maybe Mr. Conrad, would you step up? I may have a couple questions of you, so I can understand your property. And just for the record, I did miss the board review last month. But you, on your property, you have a flag lot.
Yes.
Correct?
Yes.
And you come back to, how much property do you have in
2
total?
acres.
3 acres?
2.
2 acres? So, this shed is actually going to be sort of at the end of your driveway as you come in the long flat.
Yes.
Is there anything that perhaps was mentioned in the review which keeps you from moving the shed forward a little bit further, or maybe a little bit to the right?
No, as a matter of fact, in light of my neighbor's objection, I've surveyed additional possibilities, and yes, I thought the objective was to be in the backyard because that's one of the regulations. So I tried to snuggle it into the backyard as much as possible. However, I could pull it forward such that it's only 50 feet from the property line.
So then
It
you
would
wouldn't
then be
need
in the
that.
side yard, of course.
Could you show us
Absolutely.
approximately where we're talking about, just so we have a better understanding of it? All right, so again, this is where you were proposing it, that's 25 feet. All
Okay, this is your property, and this is your neighbor's property.
right, let's have them face the same direction.
Okay.
All right, so if this is, so in essence, 25 feet is gonna be, you're gonna start here now, is this what you're
Correct.
proposing?
I would move it over here.
Okay,
Right, and I think that would make it additionally difficult for the neighbor to see it. It would be 50 feet from the property line. This would have been the most,
We don't need that variance anymore, right?
well, the side
Well,
yard.
it's still in front of the-
Side yards,
But we
It's
don't
in
need the
front
property
of the
line variance.
correct.
Right. So I'd be willing to do that. It's a little more challenging for me, but it's a suitable location.
It's the sidelines and the side, you really can't put it in that.
yeah, can we, did you saw where?
I saw.
Yeah, okay. Can- Just,
Yeah, we have it here.
okay, all right. Here?
Now, and then just for the record, you have your house, and what would be the back of your house, I presume, driveway to the opposite side. There is the gazebo, which at this point you put up and is close to the back line.
What I'd like to say about the gazebo is actually technically my understanding, I visited the building department when I built it, It is legal, actually, as it stands. It's under 100 square
Right,
feet.
it's under 100
And
square
according to
feet.
the regulations, it only needs to be 25 feet from the property line. So it is
Right.
actually technically legal and only got into this into this collection of variance appeals by accident.
And that's what I was trying to bring out.
Okay,
Because
so-
then actually, your pool is actually then behind the gazebo towards the McDonald residence,
Correct.
correct?
I'd also like to say, for all that matters, I'm not a member of the neighborhood. I'm not in that neighborhood or the other neighborhood that he mentioned. I don't know.
Right.
I mean,
Okay.
if he moves it, do we really have anything to do? What are we looking to do then?
Well, there's still the awning, there's still,
The front awning there? Well,
There's still the
objection
existing
to the
shed.
awning. There's no objection to the existing shed or the awning being expressed in that
Right.
petition, correct?
can, not from the one resident who's
Yeah.
stood up. Can we just encourage Mr. McDonald, though, to come up? Can we show you where he's now proposing to place the shed and see if this continues your objection, or? All right, here's his driveway. So he's now proposing to put it here, so it would no longer be visible.
So, I see.
His house will be
His
first.
house would be blocking your view, so it would be completely blocked.
Would it be from my property then?
Well, if
50 feet
this is
at least.
25 and the shed itself is 26, it's gonna be more than 50 feet. So in essence, it negates the need for that variance.
I see.
So we'll be giving a sideline variance.
I see.
He doesn't need a sideline variance.
Okay,
He needs a
And your
variance
general
because now
practice
it's beyond the rear line of the dwelling.
okay.
Oh,
Yeah.
there's,
I think that's what we're
we've
down
had
to.
requests for sheds
What's that?
larger than
We're
this.
just down to the house variance, right?
Okay.
And
I
then
would-
it predated,
Okay.
so.
I would agree with that. It's
No.
that way, it's away from the property, it's behind us, it's behind his house.
Okay,
I would agree with
that's,
Okay.
that's what we're hoping for.
Does he need any variance?
I don't think we need, we just,
He needs a variance because it's gonna be in front of the rear line of the
Right.
house.
Right.
yeah. Well, we needed that anyways. We're not changing that aspect of it, are we? Of this application. So there's no reason why we can't approve that variance tonight.
Okay. And the awning variance,
That's what we're looking for a,
all right, so we're now gonna eliminate the 25-foot rear line variance for a proposed 26-foot by 26-foot shed. We're gonna eliminate that, right? But is that now a variance for the shed in front of the rear line of the
In the
house?
side yard, yeah, it's not allowed in the side
but
yard.
we should have had that in here
That wasn't
anyways.
advertised that way.
Yeah, you're right.
We should have been in here, we didn't advertise it.
Because that's the front.
Is it the front, I don't know, the front lot's
The
really the
front's-
flag lot.
The front's on Clove Branch.
Right.
Yeah,
The rear is McDonald.
correct.
The side is Manila and whoever's on that
Bean.
side. Okay.
So it is in front of the rear line of the house.
Here, it was impossible
Should
for them to put
should
behind
we
the rear
clarify
line.
that on the shed and the awning in the front too, that they're in front of the rear line?
Yeah, we didn't
I mean, they were
advertise any of that
existing, you're just
stuff.
trying to clean that up, right?
We advertised for 5 variances.
John, are
That's why
we,
it's a rear line for the
does
house.
this need to be,
We never advertised
If he's going to
that
seek
the
a
shed
variance
would
that hasn't
be-
been advertised.
right, we need to re-advertise.
Yeah.
But he's applied, it looks like, for 5.
So
We
we,
ne-
so we can,
He
we can
technically
shift,
applied
we
for
can
one. change
change this, but it is gonna need to be re-advertised, okay? Especially since you're now moving it even further in front of the rear line of the house, okay?
Yeah, I think we got confused when we were looking at a rear line variance. We should have put in the advertisement that your shed and the other 2 structures, your other smaller shed and your awning is in front of the rear line of
Right.
the house, which, you know,
But note that they predated zoning.
this is a very odd lot, which would, you know, almost automatically guarantee that. I mean, you're so far
Well-
back and everything.
Okay,
With the awning, I took the 34 feet. And that should be 50. Because that's also a front line.
okay. So that's where you got the 16 foot?
Correct.
Okay.
15 down to 50 down to 34.
But again,
Correct.
it's not a shed, but it's in the front of the house.
It's a structure, but so we need a variance for all those to be in the front line, in front of the rear line, what do you want to call it, of the house.
Okay.
Front of the rear line of the house, yeah.
Yeah.
In the front yard, you could just.
I can't get my mind
Okay,
around that this evening.
Which means, John, that we have to, we're not gonna close tonight's hearing, we're
No.
just gonna adjourn it to next month.
Exactly.
With the direction that this needs to be re-advertised with the appropriate, with the changes now addressed tonight, which we appreciate everybody's, bringing that to our attention, that there was an issue. And then, so let's re-advertise it, and then, so that we're all clear, and then we'll see you again next month.
Do we need to keep the gazebo in there, or we're saying that's legal? We don't need a rear
Gazebo-
line variance for the gazebo, do we?
No, it's less than 100 square feet.
Right,
So
so
it
so
only
that
needs to be
actually
20
That
comes
comes
out.
out.
It only needs to be 25 feet.
What
That's
about the-
considered a shed less than 100 square feet.
Does that have to be 50 feet? Or is that only?
But it's still in the front line of the house.
It's just that.
In
No,
front of
no,
the
it's
rear
not.
line of the
No.
house.
It doesn't have to be 50.
Gazebo's not.
Not the gazebo, the shed. The little
Existing
shed.
Yes.
The little
Does
shed
that
is
have to be
in,
50 feet or 25?
it's in the front yard, it's 50.
It's 50
Yeah.
for a 10 by 10?
Yeah, because it's a 25 foot
Right, but
rear
again,
line.
the condition here is that these are structures that were all built before zoning, before 1963, before zoning went into effect. So, in
yeah.
essence, these were not self-created by the applicants.
Yeah.
You don't even
Okay?
have to grant the variances, they just try to clean it up when they
Right,
come
the
in
idea
for
is to clean it
something.
up, so there's
Yeah.
no. Okay, so do I have a motion to adjourn this to the July meeting with the direction to the clerk to re-advertise based on the discussion we just held here tonight?
So moved.
Second.
Aye.
All in favor? Aye. All right, we will see you again next month, and Mr. McConnell, thank you for your attention.
I think you still have to put a sign up there.
He
Make
needs to change this sign.
correct.
No, you should just be able to put a piece of tape over it or something and redo it. We
Tape
can work
that
with it,
sticks
just make sure
real
it's
good.
legible. Okay?
The rain we're having, make sure it sticks to it.
Okay,
Thank you.
thank you. Item number 3, Appeal 3631 Foreman, Neil Foreman, 103 Spyglass Hill, Hopewell Junction, is requesting a 6-foot sideline variance for a proposed 12-foot by 24-foot shed pursuant to Section 194-107 of the zoning ordinance. Good evening.
Good evening.
Motion to open the public hearing.
Thank you. Second?
Okay, move.
All in favor?
Aye.
Aye. See, please? I need you. Okay, yeah, make sure one of these gets in the file. Thank you. All right, Mr. Foreman, we did see you last month.
Yes.
We kind of walked through your concerns. You do have a backyard that slopes down significantly. And so your ability to, in terms of where you can put this shed is quite limited. The dilemma is that you have a flag lot behind you, so you have undeveloped property behind you. There's not a house there yet.
No, it's undeveloped.
But you do have neighbors who, might want to comment, and that's what we had said, let's hear
Right.
what your neighbors might comment on this property, being as we, heard some issues related to a nearby property. So do you want to just take us through why you're requesting it, so
Just
your
one
neighbors
sec-
can hear you?
1 second, just make sure you're not related to a Peter Foreman, are you?
No,
Okay.
never heard of them.
Judge Foreman.
Oh,
That's probably a good thing.
maybe I should know 'em. I should know.
Maybe not.
So,
I have, the original one, if you noticed it, was I wanted like 13 feet or 16 feet. And you asked,
Right,
and you
just
asked for
wanted
a
to put it
survey.
in line, yes.
And when I went to get a survey, he couldn't give me a survey because it was in somebody else's name, so I had my property resurveyed, and I only need 6 feet. This goes to show I didn't know my property line. What I'm trying to do is, I have a sewer clean out, and I'm trying to stay a little to the left of that.
Okay.
And I'm trying to line the shed up. It has a garage door that matches my garage doors. I'm trying to line it
Line
up
it
with
up
my
with the
driveway.
driveway, right.
That's all I can tell you.
Okay, so where you hand drew it in for us last time, we all agree now that was not the location you
You
were
agree, I
expecting
wasn't an
it to be.
architect.
Well, because no, we looked at that and just couldn't
Yeah.
imagine
Yep.
how your math added up.
You have it
so-
now, though, correct? You have the correct one now. I brought him here.
Yeah, no, I'm
Who did it?
just looking for the newer one.
Who did?
There's a lot of papers. to
Mr.
get
Foreman, who
through.
did the new survey for you?
The same, Mr. Oswald?
Mr. Oswald? Yes.
I have a copy of it. I gave him in, but I have another
Yeah.
copy of
No,
it.
I just want to make sure. Yeah, there's a survey here
Okay.
by
page
Mr.
16.
Oswald.
And it's in my name, right?
It's updated May 16, 2013.
Yeah, that's it.
Okay, good. All right, so any other questions for Mr. Foreman from board members?
No.
No,
I'm okay.
here's the survey, if anybody would like to see that. So is there anyone here to speak for or against the appeal 3631 for Neil Foreman, 103 Spyglass Hill Road, or Spyglass Hill, Hopewell Junction, requesting a 6-foot sideline variance for a proposed 12-foot by 24-foot shed? Yes?
Your name, please?
My name is Gisik Choi. I'm the owner of the adjoining property,
Okay.
107. First of all, my apology because this is my first time to be this kind of setting.
Okay.
So,
No problem.
You're doing fine.
so Mr. Foreman moved into my property. When was it? When did you move in? December, yeah. And then at that time, right after that, we had to move to Albany, letting out my property.
Okay.
So it's on rent right now. But I got the mail from this board
Okay.
weeks ago. So I just wanted to come to figure out what's going on. So
Okay.
and what's his intention?
Your neighbor is?
Okay.
That's okay, right?
If you have the survey there, that would be
Yeah.
helpful, thank you. Your neighbor is proposing he'd
You're
like to
over
put a
here.
shed in his
There's a
backyard.
tree here, and it goes down here.
Mhm.
It's down back here, like where your property starts to be wooded.
Mhm.
I'm putting it, in other words, 20 feet instead of 25 feet. It has to be 25 feet. There's a bank here, remember, there's a bank. I want to stay on top of the bank, and there's a clean out here.
Your property is immediately next door to his?
Yeah.
Yeah.
Yes, okay. So it sounds like it's this one with the,
It's right,
it's got
yeah,
the
your
woods
property's
behind it.
here.
This is exactly where I was worrying, the place that I was worrying about.
Okay,
Because the backside of the shed is heading to our property,
okay,
and it's very visible from our house. Because one of my neighbor across the road, across the street, actually had a shed in his backyard. But in his case, he's putting it in toward all the way back,
okay,
facing the wood, actually hill.
okay.
So no house there. But in this case, this shed is, the backside of the shed is headed
Oh,
to my property.
this is a practically empty lot, so there's no vegetation there to screen it. So it will be a visible, it's gonna be a visible structure.
Yeah, so if this is really needed, I want to check if I can ask him to move to other place.
Okay,
That's something less visible.
Are you concerned that you'd like us to ask for some screening or something? Would you like some bushes around it to make it, to hide it a little bit better? What do you, again, not that we have to grant it, but we're trying to see if there's some reasonable compromise that we can come to that would meet with your concerns. Is your objection, you don't want to see any structure in the backyard? I mean, he is entitled to a structure in his backyard if it's within the setbacks. In
I
this
understand
case,
it, I understand
He's
that,
asking
yeah.
for a slight variance, the 6 feet, so,
Yeah, there's a couple of evergreens, some yews or something, arborvitae, that were planted sort of in the
if
front
you
corner. Would
get
that
some tall
make it-
shrubs, would that help?
Because he's almost got 20 feet between his property and the
And your-
shed.
Right,
Yeah, between your property line and the shed is 20 feet, so you can ask the board to put some, like
Screen.
Christmas tree type trees or
Evergreen.
something,
White
or evergreen
pines.
or something, to hide the shed from your property. Because other neighbor is not here to complain or to bring it to our attention, but, your property is directly affected because it's within 20 feet. But if he moves another 5 feet, then
then you don't have a right to object. So that's why we're saying, if you're objecting, there's a concern there, we're trying to help address that concern. Because really, if he just moved it over,
5 feet,
he has no obligation to screen it. He's entitled to do that. So 6 feet, right?
yeah, something like that.
6 foot side.
So do
6
I,
foot, yeah.
do I have right to ask my other neighbors about their opinion?
They would have gotten notice about tonight's meeting already.
I
Same as
see.
you got your letter, they should have gotten their letter.
Okay, so not showing means they don't have
Oh,
any
I don't know
objection.
that anybody else is not here. I don't know. I haven't.
Okay.
You step forward first.
Yeah, because I'm the directly impacted neighbor.
So is the concern, again, that you don't want any structure at all? Do you want a smaller structure? Or is it that you want the structure to be less visible and perhaps we can ask to have some shrubs put in?
So can I take this offline and ask him to, if he can move this to other places within his property? Is it possible?
It wouldn't necessarily be offline. This is a public meeting, and some of you, like I said, some of your neighbors might be here. I don't know that they are or are not, so.
He's setting forth some very specific reasons why he wants it there. He has a sewer clean out. He wants to sort of mimic the situation with his house with the garage doors.
Right.
He's trying to present it in a very aesthetic manner from the roadway. Again, we're sort of, would like to try to accommodate that and your concerns, so. Do you understand what we say when we're suggesting that maybe some
Screening?
trees or bushes will screen it so you won't be able to see it easily? I mean, wouldn't you, is that what you're saying? You'd rather look at it, at some bushes as opposed to the shed?
His backyard is very open, so even
Yeah.
if he does move it over.
You're gonna see
still
it no
gonna
matter
see it.
what.
maybe you can have the applicant come and maybe give some suggestions of what the applicant
He's
is thinking.
supposed to be directing his comments to the board,
okay.
okay? So,
No, I mean, again, have the
I'm not
applicant.
sure whether he understands what, if there's a line.
No, it's gonna have the applicant come and read.
In other words, what we're saying, he's not asking for a big variance. It's relatively minor with what some variances people ask for. But as, in consideration of that, if he's willing to make it more pleasing to you with some bushes or something, we could suggest that to him if he wants his variance. Otherwise, if he moves it away, I mean, a change of 6 feet, and he wouldn't
right,
need a
he doesn't need your,
request,
any
and he
approval.
doesn't have to put up any bushes. I'm not exactly sure where the sewer clean out is.
Your neighbor would like to offer some comment. Would you like him to speak?
Sure.
Okay.
Yeah, he's a gentleman, I've met him once, but he's a gentleman, I understand his concerns. But maybe, I put this back here where your yard isn't finished, it's not up where your grass is. You know where you have your trees
I
and
know,
bushes?
I know.
I brought it back there, not up by my garage. It's down here where you, up here, you have a lawn. This is down where your bushes and trees are that aren't finished. I tried to make it the best I could, I guess.
Are some
don't
of
know.
those, some of
And
that,
it's a good shed, it's not a piece of junk, I paid a lot of money. I
Are
mean,
some of
I don't
the-
wanna ruin my house either.
are some of the trees that we're seeing in the aerial photograph, are some of those on your property?
They're on his.
They're all on his.
Yeah,
Okay,
they're
the
on mine.
lines don't necessarily line up
Yeah.
with the actual property lines, that's all, on the aerial that we're looking at. So in essence, though, the back of your shed is is those trees?
Yeah.
Right, okay. So so if you've got the trees on the one side, do you want some greenery, some shrubs or something on the other side? That's what we're asking, so that if you're in your backyard, at the back of your house, and you're looking over, you'll probably see some part of the building, but you'll also see some green screening.
But you would see some part of the building.
That's what I'm saying, you're
Even
still
if
gonna
you
see
moved
some
it.
portion of the building.
Yeah, without the-
I think, may I have more time to discuss with my wife? Because I wanted to figure out this first.
Want to phone a friend?
No, only my wife, because she's a co-owner of the house.
unless there's some real reason that, I mean, we can adjourn it for a couple minutes and go to the next item. I mean, we can give you that.
I understand, I'm sorry,
All
sorry for
right,
that.
so can you reach her immediately, or is this something, you're not asking us to wait till next month, are you?
If I may, next month would be better.
We prefer not to put it
Yeah,
over.
I don't see the reason to hold up your neighbor for that. You know, again, if you really object to it, then we'll consider that in our, you know, in our decision,
He really isn't asking for a big variance.
right?
And he's asking, and he's offering the screen also.
Yeah, and if
Right,
he's,
and other neighbors have asked for, you know, similar types of structures. I mean, I'm looking at this now, I don't necessarily see that there are any other sheds on the very close-knit nearby properties,
Yeah, as I said, this.
but I don't have their whole yards in the area either.
Yeah, as I said, because everything is first time, this house was first time purchasing.
Okay.
So honestly speaking, I don't know how, what kind of impact is gonna be. So that's my problem right now. So I have to,
Mr. Foreman, do you have a picture of what the shed's going to look like? I mean, I think that would help.
Might be right off, but
Plus, I think if I'm understanding correctly, that if he's at the back of his house, he's really gonna be looking at the
it's
12-foot
roughly
side
like
of
this,
it.
only a normal door like this in the middle, the windows inside, and the garage windows are the same as the house.
And the color of it?
And the color matches the house. The garage windows are the same as I think your garage is the same as that too.
Yeah,
And
something
it
like
has
that.
this door, and it has two windows and, whatever you call them, and, put a flower pots or something. I mean, it's not, but if you, I'm not, well, you have to do what you think is right.
Okay.
But if I can't get a variance, to be honest with you, I'm gonna put it 25 feet. I don't wanna, but it's
well,
gonna mess me up a little bit too, but I mean,
yeah, I mean,
you know.
we're sort
But
of
I'm not trying to be
suggesting
hard nosed either. I understand your feelings, and I'm not gonna try to ruin your property or
I'm-
mine. I paid a lot of money too. so-
I don't know, I'm not necessarily objecting about your plan,
Okay.
but I wanna assess
I
the situation.
understand,
Yeah,
I
I know.
understand.
Yeah,
Yeah, I mean,
All right.
I think the board's gonna wanna finish this up tonight. He's not asking for a big variance.
right.
We made some suggestions, and I think he'd be willing to talk to you, maybe put up a bush on the corner or something like that, so your direct view is minimized, but, yeah. we would
Okay,
like to be
then I
finished
will
it
talk
tonight.
with Mr. Foreman.
Okay, so your objections are, you'll work out with him any
Yeah,
objections?
I think I'll
Any issue?
work with him. I think we
Okay.
can do that.
Okay,
We appreciate that.
Okay,
that's a good neighborly thing to do.
okay.
Thank you.
Are there
You don't
any,
always see that.
are there any other neighbors for Mr. Foreman's appeal for his shed? Seeing none, do I have a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
It's been a long night already.
Yeah,
You gonna run?
All right, resolution?
Jim is gonna,
oh, am I gonna do it? I'm half asleep already. Okay, in reference to appeal number 3631.
Thank you for coming.
I'm all set?
no, you can.
Hold on.
Give us 2 minutes.
Actually, I want to hear my fine decision. By Neil Foreman of 103 Spyglass Hill Road, Hopewell Junction, New York, requesting a 6-foot sideline variance for proposed 12 feet by 24-foot shed. The resolution being offered by zoning board member James Meyer, and whereas the applicant has applied for the zoning board for a 6-foot sideline variance for a proposed 12 by 24-foot shed pursuant to section 194-107 of the zoning ordinance, whereas this is a type 2 action under SEQA and no further action being required by the board, whereas the legal notice was published in the Southern Dutchess News, the official newspaper of the town, on May 29, 2013, and whereas the zoning board of appeals has held a public hearing this evening, June 11, 2013, and whereas the zoning board of appeals finds that the granting of the variance will not produce an undesirable change in the character of the neighborhood or be a detriment to the community. The desired result cannot be achieved by some other means as this lot slopes back and the applicant wants the shed to line up with the driveway as well as accommodate a sewer cleanout. Actually, is that a septic tank clean house?
No, it's a sewer.
Clean out?
This is the legends there.
And the variance request is not substantial, and the proposed area variance will not have an adverse effect or impact on the physical or environmental conditions in the neighborhood. Now therefore, be it resolved that the zoning board of appeals hereby approves the request made by Neil Foreman, 103 Glass Hill, Hopewell Junction, requesting a 6-foot sideline variance for the proposed 12-foot by 24 shed pursuant to section 194-107 of the zoning ordinance. And be it further resolved that within 5 business days of the adoption of this resolution, the chair or other duly authorized member of the zoning board shall cause a copy of the resolution to be filed with the town clerk and a copy sent to the applicant or owner.
Is there a second? Second. Votes as follows. Jim?
Aye.
Aziz?
Aye.
Tara? Aye. Barbara? Aye. Myself? Aye. Your motion carries.
Thank you very much.
Okay? And your neighbor's waiting outside.
Yes.
Thank you. All right, item number 4. We are now done with public hearings. So item number 4, Appeal 3625 Kenna. Joseph Kenna, 538 Hosner Mountain Road, Stormville, is requesting a 5-foot side rear line variance for a proposed 22-foot by 34-foot garage pursuant to section 194-107 of the zoning ordinance. Mr. Kenna.
That's what he did last.
Okay, so, can we direct the clerk to send notice to Mr. Kenna that if he does not appear at the July meeting, his application will be denied? Will be deemed abandoned, thank you. That's a better way to put it.
Move that we request that.
Thank you. Well, go ahead. I made such a motion, if you want to second my motion.
Well, you said direct, I said request.
All right, so you don't want to, is there a second to my motion?
So moved.
All right.
Oh, second.
Second.
All in favor? Aye. Or do we want the word request? Okay. Must show. Okay, item number 5, Appeal 3630, Luciano, Stephen Luciano, 15 Prentice Drive, Hopewell Junction, is requesting a 2-foot variance for a 6-foot fence to be located in the front of the rear line of the dwelling pursuant to section 194-99 of the zoning ordinance. Good evening.
Good evening, how are you?
Good. We did have discussion with you at the last meeting. In the meantime, I did do a drive-by, and your original action, your original request to us was that you were looking to put a fence in place.
Well, the fence
is there.
fence is there, yes.
The fence is
No,
there,
I said
okay.
that last month, that the fence was.
Well, the discussion started, because I went and read the minutes, because I was like, I'm confused, I wasn't expecting to see the fence there. The discussion started with, that you said you were proposing to erect a fence. As it kind of went along, you kind of said, well, you can come and see it.
Well, no,
You know, that it was the color and all the rest of it.
Right.
So the fence is clearly there. You are selling your property?
Yes.
Okay, so you're trying to clear, you're trying to clear up an issue that could potentially affect the sale. I'm gonna tell you, when I drove by, I was concerned that, behind the fence was horribly overgrown. All right, it was, because you can see it from the road. It's very visible from the road.
Yeah,
I
well,
could see
it's-
the white picket fence behind it.
Okay.
That was not in the greatest of
Yeah,
shape.
well, I'm in the process of,
I couldn't see the need for this fence. I don't know if other board members have driven
wasn't
by.
aware of
I just didn't get it. I didn't see the need for it.
well, I guess when I purchased the house in 1993, there was a 6-foot fence
Okay,
on that front line of the house.
okay,
It had come down over years, trees came down, wiped out that fence. It was replaced, basically with what is there,
okay. So how
I
long
mean-
ago did this fence go in?
a couple of years ago.
Trying to understand here. So if you, a couple years ago, 2 years ago, 6
Yeah,
years ago?
about 3 years ago.
Okay. Okay, but what you told us last time around was that you have a garden behind it.
Well, it's a garden area. I'm
Oh,
not tending,
yeah,
I
it was
said it's a garden,
definitely
it's a
not
garden area.
vegetable
It's not-
garden or
no,
something like
I'm not
that.
tending
Okay.
it as a garden.
But I'll be honest, I couldn't see beyond the white picket fence. It's not really visible into your yard from the white, not that the white picket fence gives you any screening.
No,
I'm not
it's-
agreeing that it does.
yeah, it doesn't.
But it's there's vegetation on the left area there that really limited the window of the view into your yard.
I don't,
So-
well, I guess from my perspective, when I moved in there in '93, from Prentice Drive, leading all the way back, that was a pretty dense line of trees.
Okay.
Over the last few years, with the storms that have come through, most of that tree line has been wiped out. So
Okay.
from my perspective, looking at the house, it's almost completely open in comparison to what I had.
Okay.
I mean, it was a very, very private lot when I originally purchased the home.
Okay.
Over the time, you know, things have come down. I mean, the storms blew through. I mean, and I'm talking a lot of trees. There was no way to see into my backyard as you drove down Prentice Drive. None.
Well, and the way that your property is, really, you can't see, you can see very little into your backyard. So
We have a difference of opinion.
I'm just letting you know, I wouldn't be able to support this application. I did do the site visit as we told you I would.
I don't
So-
understand what the objection is, quite frankly.
Okay.
I just don't. I mean, if you could, you know, help me understand, that's,
You represented to us that you were looking for the fence to give you privacy for a garden.
no, I didn't say it was privacy for a garden. I said
You
it was
did.
privacy. I said, and behind it is a garden area.
Okay. Well, I guess, as I said, in my view from the street, as being somebody who could potentially be looking into your yard, I didn't see that you had a visibility or a privacy issue in your backyard that a lot of other properties would have. And we don't, you know, and it certainly could be accomplished by putting a row of trees there. All right, or bushes, or evergreens, or something like that. So it's not that you
Okay.
need the 6-foot fence.
There's a home around the corner on Route 52 that has the exact same type of setup, and there's a 6-foot fence on the front line of the home.
Okay?
Okay.
So what's, I don't understand what the difference is.
They may not have approvals, I don't
Yeah,
know.
again-
We don't know. We don't know what the circumstances were for that. We're acting on the application that you presented to
Okay,
us.
the application as presented, I think, is troubling me because it says to approve the installation of a 6-foot fence in place of a 4-foot fence on each side of the house. So I'm a little confused. You had a 4-foot fence, but somehow a
No,
6-foot fence showed up?
No, what
Because-
I was told is that to have a 6-foot fence, you needed a variance. There was only the 4-foot was allowed. Now, one thing I didn't realize until last month is that there's a difference between the front line of the house and the rear line of the house.
Right.
That was news to me a month ago. That's why the application, to add to further confusion, was requesting the approval for a 6-foot fence on both sides of the house, even though on the
The
right
one is
side,
clearly
it's
at
on,
the
it's
top of
on
your
the rear,
driveway,
it's
right.
on the rear line. Understood.
Why don't you just move the panels of this fence? Why don't you just move them back to the rear line of the house?
Well, as I
Because
said.
then that accomplishes the
No, but
privacy as well.
as I said last week, but then that exposes the 2 air conditioning units, it exposes the PVC piping that's coming out of the basement for the sump pump. And I quite frankly, the fact that it was there in 1993,
Doesn't mean anything.
See, the problem is, to paraphrase in a different way, the chairperson is saying she doesn't see the need for it. The problem is, our job is to enforce the law. You want us to say the law is not going to apply. You have to show a real need for it. You have to show the need
Right.
for it. We don't show that we have an objection to it. The objection is what the law says. So you have to, I mean, you're now saying you don't want the fixtures or appurtenances to your home to be showing.
Which,
Well,
again,
that's
could
not
be
provided-
accomplished
To be-
with some screening.
Which,
But
yeah, and
I will
it's
say
not providing
this.
the benefit that the fence is gonna provide, yeah, I'm agreeing. So,
but to be perfectly honest, when I looked at the home in 1993 and purchased it, I really didn't think I would have to come in here and provide a thesis as to why I needed to request this variance. Because to me, it seems to me, it seems so benign.
But even if you switch the fences, you could put the 4 foot in the
Right.
front yard, and
But-
that would still cover.
That would still cover it, I agree.
You're covering your air conditioning units.
Well, not
The
the
6
picket
foot in the
fence
back
would.
for privacy.
Sure
And
you
there's-
could.
that's a
You could-
reasonable
you could-
accommodation.
The picket,
not
it's not a
costing you
stockade
anything.
fence, it's a
Well, I
picket, it's a
understand.
picket
It was
fence.
definitely a picket fence. And-
Was it
What-
6, 7 months ago?
There are
Eight-
spaces this wide in between the posts. How
But
would
again,
that,
as
what
you're
would that
looking at it from the
camouflage?
street, even if you're walking by, I mean, I was driving by, I stopped, I checked it out because you had asked us to, but even if you're just walking by, you're not, you know, so what? You notice that there's something behind it, but you're just gonna keep walking. It's not gonna say, oh, how horrible that looks. It's just, the fence is gonna distract anybody walking by, and they're gonna look at the fence. They're not gonna focus on what's behind it.
And again, we go from the point of what the law is. 8 months ago, whatever it was, there was a person, 6-foot high fence in front line, they had to cut it down.
Right.
They had to
They
reduce
did,
it.
they took it apart.
That's what the law is. Don't always see the need to come to a stop at a stop sign, no traffic.
Well,
Don't do it, the
that's a
cop
little,
catches you.
that's a little different.
Yeah.
That's a little different.
Yeah, but,
All right, but again,
It's the
I'm,
law.
I'm,
That's
I'm
what
one,
it is.
I'm one member, I voiced my opinion in response to your, submission of your application and our review last month. Other board members are welcome to comment.
I agree with Emma, and I wouldn't support this application.
what it's coming down to, is you already have 2 deficits. I haven't seen the property, so I can't speak to that. But, I don't know, you can proceed, you can pay your fees, you take your shot, you already have 2 saying no. I can't make up my mind without seeing the property. But
I
there's a
guess
good
the-
indication you're not gonna be able to win it.
You know, I understand. I guess I'm having a tough time understanding why it is so objectionable.
Because
To
the
this
law
board.
says that's what it is.
But at the same time,
It's
so
not a
if I
matter
moved
of-
it, so if I moved it back to the rear line, which would please all of you,
Right.
it would displease me, but that wouldn't be an issue.
That's the law.
That's the law.
You take it up with the people who decide that's what the law is.
All right, we're
I
just,
guess I don't understand the practicality of that change. That's all. I mean, there are certain
I
things,
might agree
you know.
with you on a personal level, but that's not my job.
Right.
Yeah, no, I understand that.
all
I
right,
understand.
again, if there were some purpose that you needed it, you know, we've had other instances where it's been explainable why there's a need for it, then we've considered it. But I didn't get it on this one. In essence, you're really, that limited view on that left side of your home still affords you a pretty private backyard. So, but you're welcome, like I said, the best suggestion would be to replace either,
Yeah, there's also a
Change the
cost,
fences,
there's also a
but-
cost involved.
okay.
To come in and, you know, bring in, the fence contractor again to move this fence, it just, it doesn't make any
Okay,
sense to me at all.
But again, the fence shouldn't have been up in the first place. So,
I wish you would have told the guy in 1993 when he sold me the house the same thing. I mean, that's what I don't get. I mean, there was a fence there in 93.
Yeah, people
It was
put-
probably there in 1985 when the house was built.
People put up structures, they don't
Right.
follow the law, and this is why it comes in this way. So you may see the other neighbor, maybe they have a 6-foot fence, doesn't mean they follow the law. When it comes to the attention of the people that have to enforce the law, they have problems. And that's where we end up this way. Some people can then justify it, some people can't. Like I told you, 8 months ago, somebody had to cut it down.
When did it kick in?
They took the top off.
so we have 2 options at this point. We can proceed with your application, hold a public hearing, and then we take a vote and see if you can get 3 hands supporting your request, or you can withdraw your application and at least we can refund your money back.
I'll go with the public hearing.
Okay? Is there a-
Motion to advertise.
Okay,
Second?
second, all in favor?
Aye.
I'm saying no.
Okay,
Okay?
you got 4 hands.
Well,
so-
You can sell 4. That's
4-1,
fine.
yeah.
He's entitled, that's fine.
Okay, that's what
No,
I say.
I'm just saying,
Can we deny him a public hearing? I don't know.
There's 4 hands in support of the public hearing,
Yeah,
so
okay.
it's perfectly fine.
Okay.
All right, so you need to see Pam regarding your noticing requirements, and then we'll
Okay.
see you again next
But
month.
make sure that you put the sign clearly visible for all neighbors with permanent markers.
Right.
So that there is no issue of it got washed away in the rain or something like that.
Can I request pictures of the fence? And the area.
Item number 6, Appeal 3632 Martos, Pedro Martos, 40 Flower Road, Hopewell Junction, is requesting a variance to allow 5 chickens to remain on his property pursuant to Section 194-47C of the zoning ordinance.
Hi, how are you?
Good,
I'm Luz
how are you?
Marcos, is my dad. The
Okay.
reason is he has a hard time. He understands a little bit of English, but I would like to interpret if it's okay with
That's
you.
fine, no
Thank you
problem.
very much.
Dile que cuál es el problema con la gallina.
I guess our issue is, we understand that you consider these to be pets, so but the code does not allow chickens unless you have 10 acres of property or more.
Pero dile que en la ciudad de Nueva York dejan gallina
He
y
said he doesn't know why in New York they allow the chickens, and he said that the chickens are kept in the rear of the house, and it's directly in wooded area, and it's not visible, so he doesn't understand.
Doesn't matter, the code requires 10 acres.
No deja porque tiene que ser 10. And they're used for our personal use, like this is how we get our eggs, you know, and they're not for commercial use at all.
We understand that we've had applications for chickens before.
Okay.
They have not been approved.
Oh.
We've heard all sorts of stories.
y cómo dejan el caballo por los cuerdas.
He said, how do they allow them 2 acres to have
Un caballo.
a horse?
Well, that's what the code says.
Wow, he doesn't understand that.
That's what
Can,
that's
can
what the
this
code
law be
allows.
changed? What can we do to change this?
Wappingers allows chicken, I believe.
You don't encourage them to come out of town.
But some towns allow it, so I don't know which towns allow it, but you can have to find a town that allows it, so.
Yeah, it has come in before. There was a big case, it actually made the newspaper a couple times,
Right.
and, the law has been interpreted by this board for 10 acres for non-household pets.
No permiten y no va a cambiar esa ley.
Again, your recourse is you go to the town board and suggest that perhaps they change the law, change the
Can we
code.
do that?
But right now, we have to enforce the code as it
I
is.
understand. As long as we have that option, we could always try.
That's right.
Laws can be changed, right? We fight hard. Okay.
All right?
Do you want to withdraw
Do you
your?
want- Yeah, would you like to withdraw your application and we'll refund your money?
Yes,
Okay.
please.
Do I have a motion to refund
All but.
all but?
$5.
Yeah, 45.
Chicken
Okay.
feed.
So moved.
So moved, is
si
there a
quiere comprar
second?
gallina.
Second.
He said, and then would you like to buy chickens? To get rid of them.
You just got 5 weeks.
I don't have 10 acres either. All in favor? Aye. We'll refund your money.
Okay, thank you very much.
Thank
Have a
you.
good night.
Have a good evening.
All right, item number 7, Appeal 3633. I don't want to pronounce this wrong. Hi, Karan? Jackaran, okay, thank you.
Good evening.
Davenin, Jackaran, 6 Spyglass Hill Road.
I have to recuse myself in this case.
Okay, Hopewell Junction is requesting a
Mary?
7-foot sideline variance for a proposed patio pursuant to section 194-93 of the zoning ordinance. Okay, we're recognizing that Jim is recusing himself, so I'm going to appoint Mary to serve as his alternate. And you will serve on this appeal for until it's decided. All right, so you guys are requesting a 7-foot, okay, you're requesting a variance for your patio. And it is quite a nice patio.
Thank you.
My understanding is you have a pool in your backyard and you've built up the wall a little bit because you had some issues there with drainage or other things. And so now you're proposing to put a patio that's about 20 feet, I guess, on all sides around it.
Yes.
To put chairs and other things. The problem is that the patio gets awfully close to the property line. And that's why you are here before us this evening. So the issue is, you're requesting a 7-foot sideline variance, but in my review of your diagram, there's a portion of it that's going right to the property line. Have you changed your plan?
Yes, I think we changed it.
Okay? Because this is what we got with your application.
The
Okay.
architect, I don't know, he the one who designed, draw it out. He do the drawing, I don't know.
Okay, you had somebody who drew this plan for you?
Yes, yes.
Okay. Can you explain to us why this side has to be the 20 feet? Why, if you've got 20 feet on the other side next to the outdoor kitchen, you've got at least 20 feet behind it. You've got at least 20 feet on the other side of it. So the question is, do you really need 20 feet on the other side with your neighbor here?
I'm trying to put the fence straight.
Okay.
So it's not gonna be a patio, we're just gonna put the fence and I'm gonna just, no chair or anything gonna be there, just plant, flower plants and pots. Flower pot.
Okay, there's no issue with you putting up a fence. You don't need a variance for a fence. The issue is just the patio is encroaching on your property.
It's not gonna be hanging out like, I'm gonna get it level with the pool area and everything, but it's gonna be finished. It's not gonna be hanging out there or any chairs or anything gonna be there. And I'm leaving
But
four.
what I'm asking is, why can't it be green space? Why can't it be grass?
Or even plantings.
Right, or a landscape bed or something like that? Why are you proposing 20 feet of patio on the side that is,
On my
in
side?
essence, too close to your
Well,
neighbor?
I could put some grass, yeah. I don't have a problem.
Cheaper.
Now,
Yeah, it would be a lot cheaper.
um,
So
Do you-
instead of 20 feet, would you agree that you could only do 13 feet? And then you don't need a variance? You don't even need to be here?
Is there any issues with coverage?
no,
On the lot?
No, no.
because it's outside.
Yeah. Do you understand what we're saying? If you do 13 feet, it would still allow, even if you wanted to put a lounge chair or something like that, it gives you
But then
7
the
more
fen-
feet of, you've got some amount of green space or something here, landscaping or something inside the fence?
Yes.
So it would just make that area just a little bit bigger.
Yeah, I just wanna make that area nice and,
Finished. I
Finished,
understand
yeah.
that, but landscaping looks finished as well.
but, yeah. I could, probably, put in pots and, put in that area instead, I wanna do the whole thing patio and then put nice big pot.
Yeah, but we're trying to understand, why does it need to be 20 feet?
So what do you want to give me, 15 feet? Because I'm gonna leave 4 feet the neighbor side, and I'm gonna plant, some nice green shrub there.
Right? You're leaving 4 feet.
Yeah.
Feet, you can't.
No, you're leaving more than 4 feet. What's the code requires 15 for patio?
15 for patio.
15, so you're leaving 8 feet. So what we're asking is, why can't the green be 15 feet?
Because, when to mow the lawn, I can't get in, it's a big drop.
Okay, but you're already gonna get in there anyway, because you've got 8 feet.
Stairs going down on the other side.
Come on up for a second. This is the 20-foot line here, okay? And this is your fence. So you're already doing something here. You're already getting in here. What is this area here going to be? Is that green space or is that landscaping? So you're already in there mowing the lawn. So what we're asking is, why can't this line be here? You know what I mean? So it said,
the
so that instead of 20 feet, it's gonna be 13 feet.
Okay, that's fine.
13 feet is still 2, 4, 6, 8, 10, 12. So it's from the wall there out to the start of the first light there. That's 13 feet of patio. That's still a significant patio. So does that work? Because then you don't even need us. Then you can go ahead and do that without any approval from this board.
As long as you line up with the steps that you have up here. So you just basically follow these steps. and go
Right,
straight.
that's true. If you line up with the steps that you were
Steps.
proposing, you'd be fine.
Or you'd be very close, I don't know, I don't have the actual measurements, but you'd be closer.
But you
You'd be needing
You
less
re-
variance if you need it,
or none.
or none. But I won't know until I see actual numbers.
Well, I would suggest if this was 7, I'm just gonna double
Okay.
you know? that you need another 8, so, or, sorry, if this is 8, then you need 7, so it wouldn't even be that, but it would, your 20 feet here would be 13.
Okay.
All right, but like I said, it's the space from the wall to the start of that light. It's a.
It's a core length, it's a core length.
Yeah, it's a pretty significant
All right.
area,
Continue to probably.
Yes,
okay?
yeah, that would help.
Or like I said, landscaping, whatever you want to do there is fine.
Chickens?
No, no. All right? Okay, so you're gonna withdraw your application, and you can go do this tomorrow if you want to, okay? You don't have to wait for us.
Okay.
So do I have a motion
Yes.
to
Refund.
refund $45 of his application?
Well,
So moved.
he's withdrawing. right?
Yes.
Drawing. Yes.
Okay.
So moved.
Yes.
So move second, all in favor?
Aye.
Aye. Thank you very much.
Thank you.
You get your $45 in the mail.
All right, item number 8, Appeal 3634 O'Sullivan, Mary Ellen O'Sullivan, 16 Tiger Road, Hopewell Junction, is requesting a 4-foot sideline variance for a pre-existing non-conforming house and a 25-foot rear line variance for a proposed deck pursuant to sections 194-124, good night, 194-130A3, and 194-107 of the zoning ordinance. Good evening.
Good evening.
All right, so you have a home in Worley Homes, which
Yes.
is just an area that we are all well aware of has smaller lots than other places,
Right,
okay?
correct.
So the issue, as we've seen in other applications for Worley Homes, is you just don't have the requirements to meet the setbacks, or you wouldn't be able to put anything in your backyard.
Right.
So again, we have to address the existing house just because you're coming in anyway for the other issues.
Sure.
So, and and you're proposing a deck, but it doesn't, well, where's the deck? How big is your deck?
Didn't see it here, right?
Yeah, it doesn't say how big your deck is, do you know?
25 feet, I think.
Oh, it's on the survey?
Yeah, you don't get the dimension of the deck.
Okay, I have to confirm that with my husband, because he said 14, 16 feet to have enough usable space
Okay.
on the deck area, but I can get exact dimensions from him.
Okay, and so the deck is gonna be over the stone patio? It's gonna be?
Yes, so the
So it's gonna, in
footings-
essence, replace the stone patio that you had? Okay.
Exactly, it'll go completely over the stone patio that's existing.
Okay, and again, do you know where your septic is? Do you know what you have in the backyard that limits your ability to, well, actually, just because, it's just the size of your yard that limits your ability to come into compliance.
Just because.
It's
Never
just,
mind.
it's really hard because we're in the R1 zoning district and we have,
Right.
less than a quarter of a acre.
Right. Nope, I think
Yeah, I don't
we're
think we need
well
any more
familiar
review.
with that. All right, any issues or
No,
I'm good.
motion for public hearing for next
So
month?
moved.
second.
All in
Motion to
favor?
advertise, yeah.
Thank you. All right, so we'll see you next month. Please see Pam, she'll give you your instructions.
Thank you.
Thank you. If you can, just take a picture or two of your backyard, so we can just see, again, any neighbors that might come can see the limitations. Thank you. All right, item number 9, Appeal 3635 Lehigh Lawns and Landscaping, Inc. Alan Lehigh of Lehigh Lawns and Landscaping, Inc. is requesting a 20-foot rear line variance for an existing building located at 10 Sprout Creek Court, Wappingers Falls, a 10-foot rear line variance for a proposed storage bins to be used for mulch, stone, etc., a 19-foot front line variance for the existing building, and a 5-foot lot coverage variance
Be careful.
You need an assistant, huh?
pursuant to section 194-17 of the zoning ordinance. Property is in the ownership of Francis Elmendorf.
Good evening, Mark Day, Day Engineering, the assistant, Alan Lehigh.
There is a clip. Why don't you just clip it to the top?
That's bad, and your clip doesn't.
Oh, the clip doesn't work? All right, never mind.
It's okay, this'll work.
Make it feel useful.
Until his arms get tired.
We're here tonight, this is the,
Uh-oh.
I told you, Mark.
This is the Mid-Hudson Flooring site.
Right.
It's on Route 376 in Sprout Creek Court. Currently, Alan is a contract vendee. Alan owns Lehigh Landscaping on Daly Road in Tom LaGrange. I don't know if anybody's ever seen it. Basically, he does high-end landscaping projects and things like that. He's got a need, he's had a need for a long time to to relocate and to expand, if you will. He's going to keep the site on Daly Road. He wants to come here and utilize this facility. We're here tonight because what Alan needs is about 13 storage bins for mulch, stone, other wares that he uses on a daily basis. What we're trying to do is, there's a vacant, it's part of this property, but it's, if you drive by, you would almost think that it's a vacant lot, but it is in fact part and parcel of this piece. And he wants to use this area back here for storage. This is obviously the rail trail here. This is heavily wooded from here over to the rail trail. What happened was, this was all wooded too, but a lot of the trees were removed and they put in this on-ramp to the rail trail. So we're asking for a variance, rear yard variance for both the building, which is existing, as well as the 13 proposed bins. And we also need a lot coverage variance. As it exists right now, we're about 31.8% over it on the coverage. We're going to have to, because we're going to be putting an asphalt or concrete base underneath these proposed bins, we'd have to up our coverage. We'd require another 4.2% lot coverage variance.
Okay. But nothing changes in the front?
Correct.
On the 376 side, nothing changes?
Alan's going to landscape.
Right.
We're also going to change the signage out front. Right now, there's a series of mailboxes out there that have been there since Christ was a kid because of the fact that the road was never accepted.
Right.
So everybody just left their mailboxes up there, but now that the road's a town road, they're going to move everything back. And, we're going to request that the mailboxes be moved to the lots.
Are you removing any of the trees in the rear?
No, well, these aren't really trees, it's like overgrown
Scrub.
hemlock and scrub brush. But he's gonna be planting behind here, to shield the rail trail.
Okay.
And do some landscaping?
We're gonna have to get somebody. We would like to put up a chicken coop. There's 5 chickens that are right now available.
Are the bins going to have a finish to them? Again, this is along the rail trail. I know you'll have some landscaping buffer in between there. I'm just asking the question
You
for
like the word
visibility.
mafia block? That's really what they're gonna be, is concrete, stone.
The standard thing you see at usually these places?
And because
Okay,
of
so
the
it's
weight.
it's not a wooden bin
No,
with
no,
a
no.
fence that could rot and fall apart?
No, because they're loaded with skid steers and you need something to
Got it.
push the material against.
Okay.
So,
Right, you are before the planning board now?
we are,
Okay, so the planning board referred you here
Correct.
for these variances?
correct.
Okay, so aside from there, you have the fence place across the street?
Yeah, this
There's a
is
bakery on the Sprout Creek there, court,
Correct,
right?
this is vacant, I forget who's here, there's the chlorine there, and, actually.
I mean, you got the Small World Daycare right around the corner. You've
Correct.
really got no residential neighbors to worry about, except across the street and down a
Yeah,
little
this
way.
is Stringham.
Right, Stringham, right. Okay. Any questions first off, welcome to East Fishkill. All right, we certainly see your trucks around enough to know you're around, so. Questions or comments from board members? If not, do I have a motion to advertise for next month?
So moved.
Second, all in favor?
Aye.
Aye. We'll see you
Thank
next
you,
month.
thank you very much.
Thank you.
Good job.
Are your fingers still feeling? All right, item number 10, Appeal 3636 Beam, Joseph and Diane Beam, who I'm thinking are behind that board back there.
I thought we were done.
I thought we were hiding so well.
I see feet. 47 Clove Branch Road, Hopewell Junction, are requesting a variance to allow an existing 8-foot by 10-foot shed to remain 5 feet in front of the rear line of the dwelling pursuant to section 194-107 of the zoning ordinance. I do understand you are about 2 properties away from Mr. Conradi, so, but I'll tell you, I drive by your property every day, and I've watched those trees in the front there, your evergreens,
Yeah.
grow and grow, and, and I literally had to go slow down considerably for my driving skills and peer up to see where the heck is this shed? And I mean, yeah, if I'm going, 15 miles an hour and I really peer around the right-hand side, I could see it, but it is so well hidden that the dilemma is if something ever happens to those trees in the front, it's gonna be a lot more visible, no question. So, you know, the way the property slopes up, as you all know, the mountain the hill for Eagles Ridge behind it, that property is quite a significant grade going up, so it's very similar to their property.
It's anywhere from 30 to 60 degrees.
Yeah, you have
on
quite the
slope.
cut behind your home as well, so, it seems to be
It's really the
impossible.
only flat land we've got.
Right, I was
practically.
just gonna say, it would be impossible for you to actually put this at the top of your driveway. It's just,
Yeah.
you just don't have the space there to do that. So, you know, I've made it a point to, like I said, slow down and check this out, and I just didn't see that you had anywhere else to put it. Now, it is, because it is a white color, it is it's somewhat noticeable. Again, if something happens to those trees, that's the only thing I would worry about. It would become much more visible. So, I don't know if you could put one evergreen in front of it would probably hide it really, really well. So, so that would be my only suggestion, is if you could, again, just thinking along the lines of, you know, those trees are, you know, may just something happen to them. If you could put one bush, shrub, something
Sure.
in front of it.
Not a problem.
I think, you know, it would clearly, hide any concern from anybody else who might see it.
Yeah, I reviewed this application, and again, it says there are 4 footprints of remains shed, 3 of them, and then a remains of a greenhouse. What does that mean?
They were old sheds that were put up back in probably 1968, 1969, when the house was first put up. And they've literally fallen apart, and I'm in the process of pulling the parts, the broken down wood and metal out of there.
Okay, so
So-
basically,
They're not in use now?
No.
They're not structures as sheds?
No, there's literally nothing standing.
It's a foundation potentially, what might be left of each?
Well, yeah, that'd be
And
about
that's
it.
probably being generous?
Yes, that would be
Okay.
generous.
so all of these remains of sheds and the remains of the greenhouse are going to be eventually removed from
Yes, they are
from the
being
property.
removed.
So you're proposing this, again, it says existing 8 feet by 10 feet shed, and I was trying to figure out where is it physically located, because it was not in this map that was given.
It's right here. He's got really huge evergreens all
Okay,
lined up here.
this is the property this is what we're talking about.
Yeah, this is Cole Branch Road, going
Okay,
this way.
okay, this is what we're talking about, because I was looking at these guys.
Yeah,
okay.
no, so if you're
Okay,
on the
then
road,
I'm fine with it.
you
then I'm- 'cause
you
I was
really
looking-
had to slow down to see it,
Okay.
so.
Yeah, no, if this is because I didn't even identify it, so.
Oh,
They
yeah,
were just
yeah,
a box.
Yep.
Okay, I'm good.
Okay.
The only question I have is, why do you have that thing going up at the corner of your property? It's a weird shaped piece of, that's where the well is?
There is a second well up there, yes. There was a garden. The original owners had a garden
That's why you have all the-
3/4 of the way up that hill.
That's why those sheds are there.
That's why you have the
That's why
greenhouse and the shed.
up where that garden shed and
Motion to
greenhouse.
advertise.
I was so curious, reverse flag lot, what?
Yeah.
Is there a second?
Second.
All in favor?
Aye.
We'll see you next month. Just
Motion to adjourn.
Pam will give you your instructions. Motion to adjourn, do I have a second? Second. All in favor? Aye.
Opposed.
Ooh.
After the motion carries.
Let me show you.